Welcome to This Explainer. Today, we're diving headfirst into the wild world of small claims court. We're going to break down 14 absolutely chaotic cases and turn them into a masterclass on human conflict and basic legal literacy. We're talking real people, real disputes, and the staggering reality of what actually happens when communication just completely falls apart. Let's get right into it.
You know, the sheer absurdity of what people will bring before a judge it's staggering. Look at this actual quote from a grown man who sued his ex-girlfriend over closet space. Literally, a quarter of a closet and a couple of drawers. He went to a court of law to formally complain about having to step over his ex's shoes. I mean, you can't make this stuff up.
So, what really happens when everyday relationships crash and land in front of a judge? Well, when you mix bruised egos, ex-lovers, and broken friendships inside a courtroom, you basically get a circus, but it is a fascinating look at human psychology. And that's exactly why we're pulling out the absolute essential survival rules from these real-world battles. We want to make sure you never end up on the wrong side of a gavel.
Here's our survival guide for today. First up, the small claims circus. Then, Rule 1, get it in writing. Rule 2, bring hard proof. Rule 3, spite is not compensable. Rule 4, control your temper. And we'll wrap it all up with the final verdict.
All right, Rule 1, get it in writing. The danger of unspoken agreements.
Okay, so the danger of blurry lines usually starts with romance, right? In one case, a guy presents this formal $1,500 invoice for painting a condo. Sounds professional enough, but the reality? He met the woman at Home Depot, was completely smitten, volunteered to help her paint, and even bought her airline tickets to South Beach. But when she backed out of that romantic trip, suddenly he produces this itemized bill. Look, you just can't retroactively charge someone for a weekend of labor just because they turned down your invitation to Florida. It doesn't work that way.
Not surprisingly, the judge pointed out the blatant lack of a signed contract. And honestly, making it so much worse for the guy, he had actually left her a voicemail saying, and I quote, "I spent a whole weekend over there painting your place out of the goodness of my heart, to spend time with you because I liked you." He literally handed over the exact evidence proving this was a romantic investment, not a legally binding business deal. Game over.
Here's another classic example of unspoken agreements going sideways. A woman signs her roommate up for a gym membership using her own credit, totally without written consent, just assuming her friend's going to hand over cash every month. But get this, on day 3, the friend takes a pregnancy test at the gym, finds out she's pregnant, and literally never goes back. The takeaway here, you simply cannot enter into a financial contract on behalf of a friend without their actual signature, especially because unpredictable life events can completely blow up the arrangement just 72 hours later. In the end, the woman who signed up was stuck paying the collection agency herself.
Moving on to Rule 2, bring hard proof. Allegations versus evidence.
This brings us to a massive concept, the burden of proof. This is absolutely essential to understand for everyday life because just stating that something happened, that doesn't automatically make it a court-recognized fact. If you're the one making the claim, the burden is 100% on your shoulders to prove it with hard, tangible evidence.
Take the Hagen case, for instance. The plaintiff went before the judge claiming her ex-boyfriend brutally assaulted her all night long, violently throwing her around the house, holding her captive. Truly awful stuff, right? But let's look at the objective facts. When the police arrived the next morning, the officer's report noted 0 physical evidence of an assault. In fact, the report specifically stated her hair and makeup appeared perfectly neat, she was in no physical distress, and she even refused medical attention. When your dramatic claim directly contradicts the objective police report, well, your case falls apart immediately. Or check out this business dispute. A cleaning company owner sued a former worker for slander, claiming she stole all his clients by spreading malicious lies. But what was the hard proof here? Turns out, the worker simply walked into the client's offices, handed them her own business card and a voided check, and just said, "Hey, I can do the same job for you." Now, stealing clients, that's undeniably a cutthroat business move. But without a non-compete clause or an actual witness hearing those supposed malicious lies, it's really just aggressive competition. It definitely doesn't meet the legal definition of slander.
Next up is Rule 3. Spite is not compensatable. The high cost of being petty. Seriously, look at the absolute absurdity of what clogs up small claims dockets. We've got an ex-mother-in-law suing for a $100 gambling loan just because she felt sorry for her quote-unquote dejected son-in-law in Vegas. We've got an ex-boyfriend demanding $75 back for a used washer and dryer simply because he was mad about doing chores. There's even a case over a used snowboard that was gifted to a boyfriend, repossessed after a breakup, and then regifted to a friend. The court's objective message here is crystal clear. Spite has absolutely no monetary value.
So, the crucial takeaway boils down to this number: $425. Remember the guy fighting over a quarter of a closet space we talked about earlier? Well, after a year-and-a-half-long relationship ended, $425 was the entire financial value of his grand lawsuit over used furniture and a deposit. He wasted hours of his own life and the court's time proving that emotional pain rarely, if ever, equates to a big payday. You've got to just let the petty things go.
Okay, Rule 4. Control your temper. When disagreements become assaults.
Let's look at a wild chain reaction of incredibly poor choices here. A 55-year-old bicyclist gets startled by a loud shout from a passenger in a passing car. Now, instead of just ignoring it like most of us would, he goes up to an overpass and drops a pebble onto the car in retaliation. Obviously, the car pulls over and the driver gets out to confront him. At this point, the bicyclist could just walk away, right? Nope. He initiates physical contact by delivering a swift kick straight to the much younger driver's groin. The end result of all this? The bicyclist, who, by the way, was already wearing a cast for a broken collarbone, gets completely beaten up. A simple, stupid shout provoked a rock-throwing incident, which escalated into a full-on brawl where the instigator lost, big time.
Or take this incredibly volatile teenage breakup. A couple breaks up at 7 p.m. Astonishingly, the ex-girlfriend decides to return to his house at 3 a.m. to sleep over and hang out with his sister. She wakes up at 11 a.m. to find her car heavily kicked in by the furious ex-boyfriend. Naturally, the situation spirals completely out of control. It ends with the ex-boyfriend grabbing a steak knife and the girl actually getting cut and needing stitches while trying to disarm him. Look, returning to an ex's house at 3 a.m. to hang out with his sibling literally hours after a breakup, that is a masterclass in how to unnecessarily provoke a highly unstable situation.
The court's objective reality on this is incredibly harsh. If you provoke a situation, if you throw a pebble at a car, or initiate physical contact with a kick, the law is not going to protect you just because you ended up losing the fight. You simply cannot claim to be the victim if you threw the first rock.
And that brings us to the final verdict, applying the golden rules.
Okay, here is your ultimate cheat code for everyday legal survival. Step 1, write it down. A quick, simple signature saves you a $1,500 headache later. Step 2, bring hard proof. An objective police report noting your neat hair beats an hour of dramatic, emotional storytelling any day of the week. Step 3, let the petty things go. Seriously, don't drag someone to court over a quarter of a closet or a $75 used dryer. And Step 4, control your temper. Throwing pebbles and throwing kicks only ever leads to massive liability. If you follow these 4 steps, you're going to save yourself immense embarrassment, not to mention a lot of financial drain.
So the next time you find yourself arguing over borrowed money, a canceled romantic trip to South Beach, or just damaged pride, I want you to remember these cases. Seriously ask yourself, is this conflict really worth taking to a judge? Do you genuinely want a completely objective third party weighing in on your personal drama just to publicly point out how petty you're being? Sometimes, the absolute smartest legal move you can possibly make is just walking away. Thanks for hanging out with me on This Explainer, and I'll see you next time.